Thank you very much. I didn't understand everything, to be honest, but I think by now you know who I am. Although I'm a lawyer, I will not give a legal presentation, but more or less a number of observations, and if you will, take that as a comment on the podium discussion we had earlier today, at least a number of bits, and maybe it's an attempt to reconcile the varying and slightly extreme position we have heard earlier today. So I will essentially give a run-through, an opinionated run-through through the policy process that led to the not yet adoption of the current copyright directive. Because at the very, very outset in 2010 and 2015, the idea of the new European copyright rules was about at least partially recreating a balance, which is certainly an important element of any copyright system. And the biggest criticism, at least in academic circles, was that the interests of the users were not properly represented in the current copyright rules, aside from issues that the internet is getting too complicated, we need new solutions for platforms, and so on and so forth. But from a democratic perspective, it was always about recreating some sort of a balance. And traditionally, at least for lawyers, when you want to recreate a balance in copyright law, you try to tweak either in the direction of exclusive rights, or you will talk about limitations and exceptions. And my perspective has always been we need more or more flexible limitations and exceptions in the European and national copyright regimes. Now, we do find a number of new exceptions in the proposed draft for the European Copyright Directive, namely one for text and data mining, one for cross-border teaching activities, and one for the preservation of our common cultural heritage. Now, if you look closely at these limitations or exceptions, and the terminology there is always very, very inconsistent, they are very, very limited in scope. They're either limited to certain very, very narrowly described activities or limited to certain actors, to certain institutions. For example, text and data mining for the purposes of research, cross-border teaching activities for educational institutions, and the preservation of cultural heritage, mainly for cultural heritage institutions. But if you look now at the other side of the balance, you will also find the introduction of a new highly debated exclusive right, the press publishers' right, and you will also find certain provisions on platform liability, which also, at least in an earlier draft, contained a slight tweak on the right of communication to the public, to the extent that platforms that were making content available, that would usually require a license, would engage in acts of communication to the public. So these are the attempts made by the European legislator at policy level to recreate a balance. Now, it's also important to look at what the draft proposal doesn't do, what it doesn't address. And one of the most contentious points was the introduction brought forward by certain political groups of a user-generated content exceptions that would enable, most importantly, what everybody does on the internet, memes, but also instances of sampling and remixing. This has been discussed in the policy process, but had never gone to a proper discussion or a proper vote. It was floated, but never really adopted as a serious proposal. But yet, of course, these are things that everybody is doing on the internet, fundamentally important things that are supported and backed by fundamental rights. And these are things that people want to do, that we as a democratic populace expect to be able to do on the internet. And that raised the question of what is our copyright system actually for? What kind of aims are we pursuing with the copyright rules that we enact at European level? And I will try to answer that question, or give an attempt at an answer to the question towards the end of my presentation. Because there's another interesting element that within that policy process it is worth looking at, namely what the European legislator is right out ignoring. And in this case, I was looking, or I'm constantly looking at what is happening at the judicial level. What kind of contentious issues are coming in front of the court? And whilst the first proposal was coming out, there were three very, very interesting references for preliminary ruling in front of the Court of Justice pending, which still haven't been answered today. We don't have to answer these questions that, in this case, 3 times the German Federal Supreme Court was asking, but we just have to look at what issues are being raised. The first case, per others, is about sampling, whether sampling should, as a general rule, be permitted within certain limits, based on arguments of fundamental rights, as sampling as an expression of artistic freedom. People want that. The German court said people should be allowed to do that, but we don't have a legislative solution. The European legislator doesn't provide for assembly exceptions. The German legislator cannot adopt it because it's a fully harmonized field, but somehow fundamental rights, so the German courts, command that sampling must be allowed. Does the European legislator address that whilst the Court of Justice is waiting to deal with the case? Of course, the legislature is not addressing that. There are two other cases that deal with critical news reporting and how to deal with leaks from a copyright perspective. Is that addressed in the policy proposal? It is not. Should it be addressed? At least there is an arguable case that these instances should be explicitly addressed by copyright harmonization, or copyright rules should direct to other fields of law on how to deal with such very, very important instances that are rooted in fundamental rights. So the first point I want to take away, and I would certainly criticize the legislator, is that it ignores fundamental implications based on the European Charter and the European Convention of Human Rights. There's only one reference in the latest proposal from this September to fundamental rights in the European copyright rules. And if we look at how important fundamental rights have become, this is certainly too little for such an important piece of legislation that deals with a multitude of issues. It is also questionable whether copyright legislation deals with what I call normative preferences, what people want, what people would probably vote for if it were to be put explicitly at their choice, whether they want remixing, whether they want memes in their copyright rules, or whether it caters to the interests of a selective few. Interests which are certainly legitimate, but maybe slightly overrepresented. And there has been a large discussion on the role of empirical evidence in making copyright rules, whether something is economically efficient, whether a rule creates effects that create economic benefits, economic opportunities, or business opportunities, facilitate business models, enable business models, and so on and so forth. Certainly important, but at least in my opinion, not the only point that should be a consideration in formulating new copyright rules. Because if we want to take copyright seriously as a vital regulatory element in our daily lives, and if you talk about the internet, it certainly is about our daily lives, we must consider a multitude of interests. We are certainly, in order to become or to make copyright an accepted element of our regulatory environment, consider the interests of not only the industry and not only copyright extremists who want to abolish copyright, but from everyone, from civil society, from industry, and from the extremes. And indeed, to pick up one quote from this morning, we have to talk to each other, but certainly we should be able to talk to each other in a much more civilized way than the discussion that at least I have been following over the last couple of months. And I appreciate that there is discussion going on, but it should be all-encompassing, consider the interests of all stakeholders involved. And with that, I will conclude. Thank you very much for your attention. I'm looking forward to discussing these ideas with you later on.